So this is a case that just landed at the First Circuit of the United States. It's Stand With Us Center for Legal Justice, Katerina Bukin, I don't know, Marilyn Myers versus MIT, the university in the United States. And it is a case on essentially MIT allowing pro-Palestine marches, discriminating against Jewish students in the US. Right. So it says. So let's read it because I think it's important because it touches upon the specific phrases and specific acts by pro-Palestine marches that have been used to like detain and expel students from the United States. And here's a judge basically saying, no, this is not wrong. This is okay. This is protected by freedom of speech. You might disagree with it, but it is protected by freedom of speech. So it starts by saying this case emerges from a school year of tensions among students, faculty, and administrators at the MIT in response to extraordinary violence in the Middle East. Two plaintiffs are MIT students. The third is Stand With Us Center for Legal Justice, the legal arm of a California-based membership organization dedicated to combating anti-Semitism. Together, plaintiffs allege that MIT failed to take sufficient action to curtail a surge in anti-Israel and pro-Palestinian student protests, thereby allegedly subjecting MIT's Jewish and Israeli students to anti-Semitic harassment. The district court dismissed the suit for failure to state a claim. For the reasons that follow, we affirm. By affirm, it means they agree with the lower judgment, and so this is done. They lost. We begin by summarizing the facts. I'm not going to go through the facts a lot because I think it's important that we are able to get to the meat of this, but let's see if we can get the gist of it, right? Okay, so it says, on 7 October 2023, the Palestinian group Hamas launched a grotesque attack on Israel, intentionally killing hundreds of unarmed civilians and taking many others hostages. That same day, the MIT Coalition Against Apartheid, a student group recognized at the time by the university, reposted tweets from other accounts stating Palestinians cannot invade Palestine. What is, and I just want to make it clear for the purposes of terms of service, I am reading text from a lawsuit. So, Amazon, don't suspend me or anything for reading stuff that you disagree with. What is happening in occupied Palestine is a response to weeks and months and years of daily Israeli military invasions into Palestinian towns, killing of Palestinians, and the very fact that millions of Palestinians in the Gaza Strip are besieged under Israeli blockade, and progressive commentators saying Palestinians have entered Israeli territory. Baby, check yourselves, you're part of the problem. The following day, the MIT Coalition Against Apartheid and another student group, Palestine at MIT, sent an email to all undergraduate students with the joint statement on the current situation in Palestine. The statement said, among other things, that the student group held the Israeli regime responsible for all unfolding violence and equivocally denounced the Israeli occupation, its racist apartheid system, and its military rule, and affirmed the right of all occupied people to resist oppression and colonization. It was signed until liberation. An Instagram post by Palestine at MIT indicated that the MIT Black Graduate Student Association and a group named MIT Reading for Revolution also supported the joint statement. In October 10, pro-Palestinian students wrote Free Palestine, Occupation in Gaza in chalk outside a vigil organized by Jewish students. 7 days later, a student from the MIT Coalition Against Apartheid sent an email to all student group members at MIT saying that Israel dropped bombs on the Al Ali Arab Hospital and killed over 500 people and counting, an allegation plaintiffs say was later discredited by a variety of governmental and independent sources. Which is kind of funny, right? Like, it was false, okay, but is it, is it illegal to say it, even if you think it's false? Right, and actually, I don't think we can say that this was, to quote them, like completely discredited. Jewish students responded by sharing information which discredited this rumor. Okay, so no problem there, right? But were attacked online by their peers, and one unidentified student felt they could no longer participate in a study group because of this criticism. On October 19, 2023, pro-Palestinian students led by the MIT Coalition Against Apartheid held a rally outside the MIT Student Center at which attendees chanted, Palestine will be free from the river to the sea, and there is only one solution, Intifada revolution. Which is a very weird thing to get affronted by. Like, there is only one solution, Intifada revolution. they're telling you what intifada means. They're telling you that intifada means revolution. So is it illegal to call for revolution? I don't know. Like, it sounds extreme. Plaintiff Myers and another Jewish student were approached by one rally attendee who raised the front wheels of his bike at them and said, in reference to Holocaust victims, "Your ancestors didn't die to kill more people." This really caused plaintiffs and other Jewish and Israeli students to feel unsafe or unwelcomed on campus. So this is a pretty bad thing to say to someone. Like, don't talk about people's family members dying, but or like having died. I mean, particularly like this is a reference to the Holocaust. Please don't do that, right? The question in this case, though, is was MIT discriminating against students for allowing protests? Not necessarily for, existing mean comments in campus, but for allowing mass protests, right? So I'm not sure if this would be relevant to the case. I mean, saying it is an awful thing to say to someone, but does it prove that MIT discriminated against its Jewish students? I don't think so. So let's continue here. Let's see if there's anything worth saying, but I don't want to have to read all of this. So the next day, November 9, the MIT Coalition Against Apartheid, Coalition for Palestine, and other student groups led another protest in Lobby 7. The protesters included MIT faculty and staff and members of the general public. Protest chants included "From the River to the Sea," "Resistance is Justified," and calls for intifada. A Jewish student recording the protest on her phone was shoved by an unidentified protester. MIT Hillel cautioned Jewish students not to directly engage the protesters for your physical safety and well-being, and suggested that they choose paths around campus that avoid Lobby 7. Being disruptive. The campus turmoil extended beyond protests alone. November 14, MIT announced a new Standing Together Against Hate initiative to combat anti-Semitism on campus. This is sort of what MIT needs to do. So, sometime later, however, Jewish and Israeli faculty members resigned from the committee because they did not think it was doing enough to address anti-Semitism on campus. Okay, but it existed. I mean, again, I'm not sure how this proves that MIT was not doing enough. In the November-December 2023 issue of the faculty newsletter, MIT professor Michael DeGraff published an opinion expressing support for pro-Palestinian student protesters, denouncing ongoing bombing, that is, war crimes against hospitals in Gaza, and genocide of Palestinians by the Israeli army, and arguing that racism might be fueling the MIT administration's alleged decision to denounce anti-Semitism but not Islamophobia with regards to the campus protests. The letter closed with a slogan "From the River to the Sea, from Gaza to MIT." Again, freedom of speech, right? As far as I'm concerned, it's not illegal to say that there's genocide in Gaza. On the contrary, it is following the law to say so. Skip. Essentially, what this is showing is that there was a lot of protests saying things that made Jewish students uncomfortable. According to plaintiffs, throughout the spring, MIT allowed what plaintiffs call anti-Semitic posters to be displayed on campus. As an example, plaintiffs point to a poster that remained hanging for approximately 1 month, depicting two fists in handcuffs and proclaiming "No to Zionism and racism." People don't need to like Zionism or racism. Let's see what else. I really don't want to have to read all the facts because I don't have time for that. Nonetheless, the encampment continued, and on May 3, 2024, MIT installed high fencing around the encampment to contain it. Again, it seems like MIT did a lot, right? Probably more than it should have. Like, high fencing around the encampment seems excessive. The following day, journalists recorded protesters at the encampment chanting slogans in Arabic, which, according to plaintiffs, could be translated as "From the water to water. Palestine is Arab. Palestine is free. Israel out. We want to talk about the obvious. We don't want to see Zionists. The iron gates of Al-Aqsa open for the martyr are from water to water, death to Zionism." By May 6, 2024, the encampment still had not ended, and MIT attempted to draw a harder line. It informed protesters that if they did not depart by 2:30, they would face discipline. Again, this case is about MIT not doing enough. It feels to me like MIT was doing a lot. Strategy backfired. The protest organizers posted on social media calling for others to join the encampment. As tensions mounted, an individual jumped over the fence surrounding the encampment, sparking a surge in which a new wave of protesters breached the fence. By the evening of May 6, approximately 150 protesters had gathered at the encampment. They couldn't, celebrate the state of Israel. Protests intensified. Yada yada yada. Okay, so we get the idea of the facts, right? This is the legal standard that they're using. Title 6 of the Civil Rights Act mandates that no person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. To hold MIT liable for violating this mandate, plaintiffs pursue a hostile environment or harassment theory, analogous to the theory of liability developed in Title IX. Under this theory, a school can be held liable if it was deliberately indifferent to severe, pervasive, and objective offensive harassment that caused the plaintiff to be deprived of educational opportunities or benefits. Is it harassment to do an encampment, though? I'm not following. Though these cases involve the sexual... this doesn't matter. As we will explain, plaintiffs' proposed use of this theory fails for two independent reasons. First, plaintiffs' allegations do not plausibly rise to the level of actionable harassment required by Title VI. Second, even if the protesters' conduct as a whole was actionable harassment under Title VI, MIT is not liable because it was not deliberately indifferent to the effects of the protest on Jewish and Israeli students. Yeah! MIT did a lot from the recollection of the facts, so it isn't really liable. This theory, it feels like such a waste of time, to be honest, to argue this. So it says, our conclusion that plaintiffs have failed to allege actionable racial harassment consists of three parts. To begin, most of the conduct about which plaintiffs complain is speech protected by the First Amendment, and we do not construe Title VI as requiring a university to quash protected speech. Furthermore, by gathering together in groups on campus, disrupting campus tranquility, and impending travel for many students, the protesters did not render their speech anti-Semitic, much less unprotected. Finally, to the extent that plaintiffs allege isolated incidents that are plausibly anti-Semitic, the complaint allegations are not sufficiently severe, pervasive, and offensive to constitute actionable harassment under Title VI. So I agree completely with this. From the short review of facts, it seems like, yeah, there were like anti-Semitic events against specific students. But the standard for MIT is not that there should never be any anti-Semitic event, is that those anti-Semitic events that it is aware of and it can act on, it should act on. And if it cannot act on the specifics, it should act generally to prevent them as much as they can. It sounds to me like that's what MIT did, so I don't see the point of this lawsuit other than to try to get a judge to say that From the River to the Sea is anti-Semitic. Ikonaka says, wasn't this the lawsuit brought by A.L. Jacoby's team? I think that's another lawsuit, because A.L. Jacoby was in Columbia, not MIT. Right, Columbia, I think. I'm not sure. It's not him, though, because he's not with the plaintiffs. Because plaintiffs base their claim so heavily on what the protesters said and wrote, we consider first whether plaintiffs' proposed application of a harassment claim under Title VI comports with First Amendment principles. The Supreme Court has long recognized a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open. By removing governmental restraints from the arena of public discussion, the First Amendment places this decision as to what views shall be voiced largely into the hands of each of us, in the belief that no other approach would comport with the premise of individual dignity and choice upon which our political system rests. So I'll be honest, I think that is probably way too overboard for free speech. Like, I do think there is a need for government I'm pretty expansive on my interpretation of free speech. But I do feel that there should be some government intervention when it comes to like hate speech or like stuff like that. Um, I guess I'm somewhere in between Europe and the United States. I think the United States is too lax. I think Europe might be too constrained. In light of this overriding interest in open debate, speech made in public that is related to matters of public concern has been given special protection under the First Amendment and thus cannot be restricted simply because it is upsetting or arouses contempt. Which is the main problem with the United States, right? It argues, like, for example, if you go to an abortion clinic and you start harassing young women who are going into an abortion clinic to get an abortion, in the US, they will say, oh, well, you might get upset, but that's lawful. Whereas in the UK, I think the right argument is, look, you have a right to free speech. You don't have a right to be heard by a person who will be made to feel harassed by that speech. So you can absolutely be in the vicinity of an abortion clinic, but you cannot be at the doorstep of the clinic because then that's harassing. I think that's a much more reasonable approach. But I mean, in the US, there are basically no limits, right? So you want to win this case under the First Amendment? You're not gonna. The only way that you would is if you have a judge conclude that From the River to the Sea is anti-Semitic. Um, yeah, so so they cite Snyder v. Phelps, right? This case is the case protecting speech of Westboro Baptist Church protesters chanting "God hates you," "Thank God for dead soldiers," and priests rape boys at a funeral for a deceased soldier. Like, if this is protected speech in the United States, and let me be clear, I do not think that this should be protected speech. I think that you don't have a right to go to someone's funeral and say that God hates the person that died. You don't have that right. You may have the right to say that God hates that person, sure. You don't have a right to say it in a place where other people can hear you in that funeral. But this is the standard that you're fighting in the United States. You're crazy to think you're going to win. Yada yada yada. This is all legal standard. Similarly, the Supreme Court has long upheld that the essentiality of freedom in the community of American universities, warning that to impose any straitjacket upon the intellectual leaders in our colleges and universities would imperil the future of our nation. This is the key thing, though. If this gets certiorari and goes to the Supreme Court in the United States, this can all come crashing down. Because if something has been clear in this genocide, is that the West is willing to destroy itself so that Israel can destroy Palestine. The West is willing to do away with all of its principles so that Israel can kill Palestinians. It's mind-blowing to see. Here, the student protesters engaged in speech on a matter of public concern, the conflict in Gaza, while on the campus of a private university in which they were enrolled, MIT. MIT chose to restrict that speech in part and allow it to continue in part. Now, plaintiffs seek to hold MIT liable under a federal statute for its failure to curtail that speech even further. Okay, good luck. As a private institution, MIT could choose to curtail political speech by its students without First Amendment scrutiny. But MIT's authority to decide for itself whether to prohibit certain political speech is not the issue here. Rather, the question is whether Title VI required MIT to try to put an end to the protesters' speech. And requiring MIT to restrict students' expression merely because those students opposed Israel and favored the Palestinian cause would infringe upon MIT's freedom to encourage rather than suppress a vigorous exchange of ideas. Using Title VI to compel adherence to a preferred political viewpoint would also implicate students' First Amendment freedoms. A law punishing private citizens for expressing political opinions disfavored by Congress would be subject to the most exacting First Amendment scrutiny. When the government targets not subject matter but particular views taken by speakers on a subject, the violation of the First Amendment is all the more blatant. As such, the government must abstain from regulating speech when the specific motivating ideology or the opinion or perspective of the speaker is the rationale for the restriction. Viewpoint restrictions are all the more perturbing in the context of speech the government deems offensive. Nor can the restrictions of an offended audience serve as grounds for the government to suppress such speech. So facts don't care about your feelings. Right? You have a right to offend, basically. It makes no difference that in this case, restriction of speech comes by way of a civil suit brought by private parties. Congress cannot skirt First Amendment concerns by passing a law requiring someone else to punish protected speech. Let's skip this. This is all legal standard. You guys don't care about this. In sum, the First Amendment erects safeguards that limit the ability of the government or private plaintiffs to punish MIT for not restricting more severely the students' protesters' protected speech. That's pretty self-explanatory, right? In view of the underlying conclusion, we find no surprise in plaintiffs' agreement that courts should interpret Title VI to comport with the First Amendment principles. Plaintiffs argue that much of the protesters' speech fell outside the protection of the First Amendment and thus within the reach of government censor, because the speech was racist, i.e. anti-Semitic. This argument poses two nettlesome issues. First, under what circumstances, if any, can racist speech be punished pursuant to Title VI without violating the First Amendment? See Davis reviewing the difficult First Amendment problem raised by university speech codes designed to deal with peer harassment. There's no categorical harassment exception to the First Amendment. That's crazy, man. The US is crazy. Yeah, that's crazy. To suggest that the protesters as a group were guilty of anti-Semitism, plaintiffs point to two categories of expression by protesters: the chants, emails, and signs that formed the general thrust of the protesters' message, and the gatherings that impeded movement on MIT's campus. We consider each category, beginning with the verbal and written messages that focused and spread the protesters' views. So we're going to do A, we're not going to do B. Okay, no time for this. The sordid history of anti-Semitism provides a litany of epithets and tropes widely understood as expressions of religious or racial animus. As described by plaintiffs, the scores of protesters holding handmade signs and voicing various chants eschewed those epithets and tropes, directing their ire instead at the Israeli state and its treatment of Palestinians. To support their claim of anti-Semitism, plaintiffs point to the protesters' opposition to Zionism, which they argue is inherently anti-Semitic. Zionism, plaintiffs explain, is the belief that Jews have the right to self-determination in their ancestral homeland of Israel. I always don't like this definition, because if that were the case, then Israel as a state should not necessarily need to exist under Zionism. Self-determination is a right that can be expressed through non-state means. So if this is what Zionism is, then the creation of Israel was not a Zionistic ideal necessarily, because what Zionism is the belief that Jews have the right to self-determination in their ancestral homeland of Israel through a state designed exclusively for them. That's Zionism. That added is necessary. There should be a nation state for Jews and no one else in Israel Palestine. That's Zionism. It's not just about self-determination, because, I mean, Jewish students in New York, in MIT, have self-determination as Jewish students. They just don't have sovereign self-determination, external self-determination. So they have self-determination as Americans. So this is a very deficient definition of Zionism, in my opinion. But anyway, I digress. Plaintiffs argue that because most Jews see Zionism as a key component of their Jewish ethnic and ancestral identity, anti-Zionism is anti-Semitism. In plaintiffs' view, speech is anti-Zionist and therefore anti-Semitic if it opposes Jewish self-determination in the state of Israel. If it claims that the existence of the state of Israel is a racist endeavor, I mean, can I say that all states are a racist endeavor? If it requires of Israel a behavior not expected or demanded of any other democratic nation, no nation is expected to commit genocide. And if it draws comparisons of contemporary Israeli policy to that of the Nazis. Under this framework, plaintiffs also treat as anti-Semitic any criticism of Israel's conduct in Gaza. Any suggestion that violence by Palestinians can be understood as resistance to colonial rule and Israeli expansion, and any implication that Palestinians should govern or even simply be free in all of Palestine. This is crazy. Like, freedom cannot be anti-Semitic. Let's establish that, okay? Being free is not anti-Semitic. Plaintiffs are entitled to their own interpretive lens equating anti-Zionism, as they define it, as anti-Semitism. But it is another matter altogether to insist that others must be bound by plaintiffs' view. Oh, ouch. Okay, they lost. Plaintiff's equation finds no consensus support in dictionary definitions, nor does a review of the academic literature point to any consensus that criticism of Zionism is anti-Semitic. Ouch. And we do not find it dispositive that the United States Department of State has defined anti-Semitism as denying the Jewish people their right to self-determination, for example, by claiming that the existence of the state of Israel is a racist endeavor. Office of the Special Envoy to Monitor, blah, blah, blah. This is a quote. As the Supreme Court has repeatedly emphasized, new categories of unprotected speech may not be added to the list by a legislature that concludes certain speech is too harmful to be tolerated. This absence of consensus reflects ongoing debate as to the relationship between anti-Zionism and anti-Semitism, debate that our constitutional scheme resolves through discourse, not judicial fiat. Thank you. On this, I am in complete agreement. Like, you cannot just go to a judge and say, declare that this is anti-Semitic and therefore unlawful. That would be prior censorship of speech. Indeed, the debate on occasion has been formal and high profile. See the Monk debates, debate on Zionism and anti-Semitism, Intelligence Squared, blah, blah, blah. We decline to interpret Title VI as arming either side of that debate with the powers of a censor. This is very well written, honestly. So the court is saying, look, you are in a debate for the heart of Zionism. You're in a debate as to whether what you believe is racist against Palestinians or not. You do not get to rope me in as a judge so that you can win the argument. Go win it. I mean, that's fair. The thing is that they're losing that argument massively after winning it for decades. And they're freaking out. And because they're freaking out, they're seeking for the judges' help. And the judge is saying, I won't help you win an argument. That's not my role. MIT also had to contend with the inverse of plaintiffs' contention, that Muslim and Palestinian students could, by similar logic, claim that expressing support for Israel's actions in the West Bank and Gaza was Islamophobic and anti-Arab. Indeed, plaintiffs' complaint cites a faculty note arguing that MIT's response to the campus conflict manifested racism against Arab and Muslim students. We struggle to imagine how a university faced with such conflicting views could plausibly eliminate all unwelcome speech without quashing all speech concerning the conflict between Israelis and Palestinians, particularly because, as MIT's President Kornbluth observed in a statement cited by plaintiffs, MIT's community include both people who lost friends and family to the brutal terror attack of October 7th and people with friends and family currently in mortal danger in Rafah. This is not to say that anti-Zionism is never wielded as a tool of the anti-Semite. Gartenberg v. Cooper Union saying, finding that, this is the citation, finding that from the river to the sea, Palestine will be free graffiti on a bathroom stall that was made to resemble the stylized font commonly associated with Hitler's Mein Kampf could be used among other evidence to show anti-Semitic motivation. I mean, that's fair. If you're citing, like, if you're trying to make your speech look like Mein Kampf, then you're anti-Semitic. It is to say instead that one person does not lose the right to express a political opinion on a matter of public concern merely because another who expresses the same view does so for condemnable reasons. One individual might criticize a government program as an inefficient use of taxpayer resources. Another might criticize the program because of hostility towards its beneficiaries on the basis of their race or religion. The latter's individual view, while reprehensible, could not justify restricting the former individual's speech nor imposing a categorical ban on criticism of the program. Yes, but this is tricky because that's when you get to this, like, I'm not actually saying that there are superior races, I'm just saying that there are superior cultures kind of argument that the fascist right now makes. It's not just your expressed intent, it is also the context, right? So I would be cautious with this standard. Oh God, what is this? So NAACP v. Claiborne Hardware, that's the quote, that's the citation that they're using here, holding that civil rights protesters did not forfeit their First Amendment rights merely because certain group members' conduct exceeded the scope of constitutional protections. And Black, 538 US, the act of burning a cross may mean that a person is engaging in constitutionally prescribable intimidation, but the same act may mean only that the person is engaged in core political speech. US. What? Like, I need more data points here, but like, what? I think it's pretty clear what burning a cross means. Nor can the possibility that anti-Semitism motivates one speaker's anti-Israel speech justify assuming that all criticism of Israel or advocacy for Palestinian sovereignty is motivated by anti-Semitism. Yes. We therefore reject plaintiff's claimed right to stifle anti-Zionist speech by labeling it inherently anti-Semitic. Nor do plaintiffs allege facts that, if true, would otherwise permit the inference that in these specific circumstances, the protesters' strident criticisms of Israel were driven by anti-Semitism. Exactly. It's not enough for you to say, I feel offended by that. You also would need to say that you feel offended by that and that the intention is to be anti-Semitic, right? That the intention is to harass you. The intention is to do more than just express a political opinion and turn your opinion into fact, turn your opinion into action. That you were seeking to cause harm on someone else. That, to me, that's the limit of freedom of expression. You cannot say, go kill all the X group. But say, for example, one typical thing is like, in Peru, we had this like discussion. Is it discriminatory if a Catholic priest says in school that homosexuality is a sin? Because it is a figure of authority telling a student that what they are is sinful. And it's a difficult case for me because, like, in that regard, it is factually a sin. And the correct thing to do, in my opinion, would be to say, I mean, that is what the Catholic Church believes. You just don't need to be Catholic. And they don't get to impose those views on you because you're Catholic. And even if you are within the Catholic Church, you still get to fight for what you want your church to be. So I wouldn't consider that speech banned. But if you are, as a Catholic, you are harassing a student because they are gay, then that's different from me, right? It's one thing to state the fact that the Catholic Church says that homosexuality is a sin. It's another one to use that fact to harass, bully, and oppress, right? That's, to me, the difference. Jartov says burning a cross is a specific reference to KKK burning cross in black neighborhoods as an intimidation campaign. Yes, I can imagine a protester burning a cross in front of a Catholic archdiocese office because of their rapist priest shuffling. The judge is saying the former shouldn't stop the latter. Yes, but I mean, it is not very common for Catholics to burn crosses in response to the church rape accusations. But I see your point, I guess. I don't know if that would be a very common occurrence, burning a cross for another reason. So without such an inference of anti-Semitism, the protesters' speech cannot constitute racial harassment for Title VII purposes. I agree with this. Here, plaintiffs prefer only conclusory allegations of anti-Semitic animus that are not entitled to be assumed true. Plaintiffs allege no facts plausibly establishing that the protesters as a group opposed Israeli actions in Gaza or supported the Palestinian cause because of anti-Semitic animus. Nor do plaintiffs allege facts plausibly showing that the protesters as a group shared plaintiffs' view that anti-Zionism was inherently anti-Semitic. We also reject plaintiffs' implicit contention that the choice to criticize Israel's actions in Gaza, rather than, for example, choosing to criticize some other alleged atrocity elsewhere in the world, necessarily manifests anti-Semitism. This is the "why don't you talk about Sudan" thing. Because I want to talk about Gaza is a very obvious answer, and this is what the judge is saying. Political advocacy, by its nature, involves a choice to focus on certain issues or causes over others. Title VI does not preclude the protesters' U.S. university students from responding to the headlines by choosing Israel as their target, particularly given the protesters' perception of the significant role played by the United States and the U.S. supplied arms in the conflict between Israel and Palestinians. So essentially, you get to be angry about whatever you want to be. Finally, plaintiffs point to the fraught subject of genocide. First, plaintiffs claim that accusing Israel of committing genocide against Palestinians is anti-Semitic, but even prominent Israelis have lodged the same accusation. They quote the Omer Bartov article in the New York Times. Second, plaintiffs claim in their brief that some protesters called for the genocide of the Jewish people, but there are no factual allegations supporting this claim. Rather, plaintiffs say that we should construe chants of "from the river to the sea, Palestine will be free" and "Intifada revolution" as calls to wipe out the Jewish people as such. But neither slogan says as much on its face, nor do plaintiffs allege facts suggesting that either chant was commonly so construed by the protesters. So plaintiffs must again rely on a theory that they can dictate the interpretation of the protesters' speech in order to suppress it. Brilliantly put. Perfectly put. No notes. You do not get to tell people what they mean by saying stuff. It's like when I say when I refer to someone as a gringo, and people tell me you're being racist against Americans because that is a racial slur. And no, it isn't. I have uncles that I call gringo. I have friends that I call gringo. I have family that I call gringa. Right? And these are perfectly acceptable terms in my own estimation. Why would I call my aunts and uncles gringo and gringa? Right? So you don't get to tell me, oh, but I feel that that is different. It's not like I am using a word that is like universally regarded as discriminatory, like say the N-word. And even the N-word, like I would say in certain contexts, is acceptable. You just don't say it because it's discriminatory, right? Within certain communities, it is acceptable. It's just not acceptable for me to say it. So you don't get to dictate the meaning of words for others. The only scenario where you can do that is where there is no other possible interpretation. It's like the cross burning thing. Like I can't think of another scenario where burning a cross would mean something else other than racism. That's true. You cannot go and say, "Oh, I just don't like crosses." That's different. But these two chants have such a long history of such a long history not associated to genocide that it's quite silly to turn them into genocidal chants. So without any facts suggesting that the protesters were using these slogans in the plaintiff's claim. In reviewing these claims, our role is not to approve or disapprove of the protesters' strident advocacy, nor of the ideas they so vigorously expressed. We do not question the anguish plaintiffs felt at hearing a few of their peers justify the October 7th massacre or deny Israel's right to defend itself. But our constitution bars the government from forcing a private university to prohibit students from voicing vehement support for or opposition to the policies and conduct of the United States and its allies. For these reasons, we decline plaintiffs' invitation to hold that the protesters' speech constituted anti-Semitic harassment, actionable under Title VI, merely because it was stridently pro-Palestinian and anti-Zionist. That's it. So I thought this was very interesting, and I generally agree with what the judge said. I have some things here and there that I would disagree with because we're operating under the US system, which like I said, I think is too extreme. But overall, I think this is a pretty solid case. My fear is that this will be appealed to the Supreme Court, and the Supreme Court will just say these are anti-Semitic chants, done. But I feel like this is the correct approach. And I'm glad that these cases are starting to pop up here and there, because yeah, we have endured for 2 years this onslaught of propaganda, like UNRWA is Hamas, then the ICJ says UNRWA actually isn't Hamas. There is no famine, and then all of a sudden the Gaza Humanitarian Foundation is disassembled in the Trump peace deal because there actually is famine, and Israel is told to increase aid because actually there is famine. All of these things are crushing down, basically. All of the lies are finally crushing down. And I think it's important that these cases exist because it is important for us to know that they are lies, that they are propaganda, they're not true, that these are all, I don't know, desperate moves by individuals who see what is happening in the world, a world that used to be very comfortable for their oppression of others, and they're now losing that power to oppress. They're losing that impunity to oppress, and they're freaking out. And they want that impunity back. And they're trying to get it through sanctioning prosecutors, through sanctioning judges, through suing students, through deporting students, and through using the power of the government to their own benefit. So this is a very welcomed decision. And I thought it was important for us to read it so that you have it in your radar. Just to remind you again what this opinion is, this is Stand With Us v. MIT. Okay? Okay, it is 7 p.m. So I'm going to go cook dinner and I'm gonna leave you guys again. And hopefully see you again next weekend. Thank you to everyone who was here on a Sunday talking about, you know, the new Francesco Albanese report and this decision. Um, Thank you again for always coming. Thank you for always being, the same people. I like my Sunday crowd. I like my people. I like all of you. Thank you so much.